Thank you for tuning in to this week's edition of the Beck Law Office Q&A. On this episode, I'll be answering the question, does the lemon law apply to used cars in California? The answer is yes, but the type of used car and the form of compensation you'll receive does differ. Under the California lemon law, a consumer is entitled to a statutory repurchase. And a statutory repurchase, as discussed in other episode, is essentially a refund of the amounts that you've paid and still owe total, less a reasonable mileage offset credit back to the manufacturer. And this is still the state of the law as it pertains to certified pre-owned cars sold to the consumer by the dealership. Now, certified pre-owned meaning the manufacturer has certified an additional warranty on a used car that their dealership has sold to a consumer. Well, no longer is the case that this applies to used cars. So the statutory repurchase, the Court of Appeal determined, does not apply to used cars, not certified pre-owned, and didn't really clarify what a used car owner who does have an original warranty still intact when they bought that used car and has problems that cause it to become a lemon, didn't really clarify what that consumer is entitled. Instead, they alluded to the fact that they're not going to be addressing what other contractual remedies that consumer might be available. So those other contractual remedies might be contract rescission, canceling the contract and getting a complete refund, which is probably not what the court had in its mind or in its reasoning when it made this decision, because that would result in a greater recovery than a statutory repurchase, because it would be less any sort of mileage offset, just a complete refund. So it's probably not contractual rescission damages, at least according to this court opinion. The other contractual remedy potentially could mean is revocation of acceptance, meaning whatever balance you still owe after you revoked accepting that agreement to buy the car and pay it off. So you still owe $10,000 on the car, you revoke acceptance, potentially you would no longer have to pay that. Revocation of acceptance damages, that $10,000, it would be canceled or paid for by the manufacturer. But in addition to that, it's pretty clear that incidental damages like out-of-pocket expenses, also discussed in another episode, would be included in the recovery that a used owner of a car still under warranty that became a lemon, not certified pre-owned, would be entitled to. So we have out-of-pocket expenses, definitely, revocation of acceptance or whatever you still owe on the car, recovery, maybe. But then there's protections under the federal lemon law, which provide for arguably diminution in value. So you could be looking at, as a used car owner with a lemon, not a certified pre-owned, out-of-pocket expenses, potentially diminution in value, and potentially revocation of acceptance. Thank you. Hopefully that answers your question. If you have any more specific questions, please feel free to give me a call or send me an email.